I'm Paul Cawthorne. I work with Médecins Sans Frontières and I'm the coordinator of the Access to Medicines campaign in Asia. So free trade agreements are normally negotiated. The intent is to reduce trade barriers between countries. So, for example, one of our big concerns at the moment is the negotiations that are ongoing between India and the European Union. These free trade agreements cover a huge range of trade topics, but particularly for MSF, our major concern is that the European Union are attempting to push India into agreeing to increase the intellectual property barriers to essential medicines. ACTA is it's a negotiation that's been taking place between a small number of mainly developed countries, US, European Union, Australia. The idea for ACTA is that they want to use this agreement to, they argue, to prevent or reduce the amount of counterfeit and fake medicines on the international market. Our big concern is that rather than stopping counterfeit and fake medicines, potentially some of the clauses in ACTA would prevent transportation of legal generic medicines, for example from India. Potentially they could be seized in a European port on their way to another country, for example in Africa. If ACTA goes through in the way that we think it will, one of the big problems will be that it will allow companies, big pharmaceutical companies, to use ACTA to threaten, for example, generic companies producing low-cost drugs, saying, look, you're producing a copy. They could argue that this copy is therefore infringing their patent, even though in the country it's being produced in, it's being produced legally. One big problem with ACTA is that it changes the legal balance. So in the past, before ACTA, if a company believes that another company is infringing its intellectual property rights, it takes a civil action in court against that other company. And it's carried out in the court in the country where the supposed infringement happens. If countries sign up to ACTA, then it limits the capacity of the judges to rule based on the public good. It also, in ACTA, would mean that if the court case ruled against the infringer, the company holding the patent could also then take out cases and get compensation, not only from the company itself, but for example for companies that have provided raw materials. So it suddenly makes the potential for legal infringement cases much more likely, and for the damages that go from that much bigger.
So if ACTA...
One big concern is that agreement, which is between a handful of countries, will then be pushed on other countries to sign. Particularly, for example, the European Union could then start and say, in our free trade agreements with, for example, Malaysia, Singapore, Thailand, we want, as part of that free trade agreement, for those countries to accept ACTA. So the problem is that once that is agreed, it becomes a kind of template for the future for other countries, even though those countries were not involved in the ACTA negotiations. We would argue that if countries were able to access safe, effective, affordable generic medicines, then the fake and counterfeit medicines market would die out because people would be able to access drugs that they could afford. Ideally, it would be best if civil society in all countries that feel that their access to medicines, for example, would be threatened, have some kind of public demonstration so that the European Union becomes very aware that the public are against the clauses in the FTA that would threaten access to medicine. Even better would be if we could mobilise big groups of people in Europe, but that's quite difficult at the moment to get that to happen. So basically having mobilisation of large numbers of people, sending a clear message to the European Union that they do not want stronger IP protection on medicines.